Good evening, sir. Then you may start, sir.
Yeah, I'll start.
Okay, sir.
आप जब भट्ट साहब को बोल दीजिएगा. Good evening, everyone. This is supposed to be a lecture on how to deal with the drafting paper. Now, three things are which I want to put to you. Three things, very important things. One, please remember that in every petition or appeal, whatever you draft, there are 4 or 5 basic factors which you must keep in mind. The basic structure of any draft which you have prepared will always have to be first under what provision of law you are setting up the draft. That is, if it is an SLP or if it's an appeal or if it's a writ petition or any other an application. First, what provision of law? Then, what is exactly the point in one paragraph? At least one point what you are raising. What is the issue you want to be discussed? Then an introduction to the parties. Who are the petitioners? Who are the respondents? That you must put in detail. Then you must give a set of facts as to how the petition has come up, whether it's a writ or an SLP. Once you do that, then you go to the actual submissions as to what is your submission, why this petition should lie, why it has to be taken up, and then, of course, the grounds and the prayers. If there are any questions of law involved which you are required to have, like in a second appeal or in an SLP, then these come before you give the just before you give the grounds. The other issue is that SLP in Supreme Court has a different format which has been prescribed by the court. So you are stuck with that format. Now, in SLP's format, what you must remember is that the synopsis is practically what judges will look at. So even in the AOR exam, your synopsis should be putting your real issues and thoughts right in up front. Put that, then of course you go to the format of the SLP, which will again is a very formalized formula. You have to give it. Now in the exam, in an AOR exam, the biggest problem which most of you will find is that you have lost the habit of writing by hand. You are all busy punching the keyboard in laptops and computers. So you have to get into the habit of writing by hand. Number one. Number two, they require, this is a drafting paper. This is not what I would call a paper on the legal aspects. It's basically a drafting paper. So you must be prepared to put every aspect of the draft there. Now, I've noticed in some of the earlier questions papers that they have said don't put a certificate, don't put the filing index. Fair enough. Give the first page, then give your synopsis, then your main matter, then your application. Now, affidavits are integral part of the drafting. So affidavits have to be very clear. You have to put the person who is filing the affidavit, who is submitting the affidavit, how he is authorized to do it, what is the affidavit in support of. Supreme Court has one benefit, and that is that when you draft an affidavit, you can mention all the applications in the same affidavit. What is said in the SLP is this, and what is said is all true to my knowledge. In high courts, you have to file a separate affidavit with every application. Here, you don't have to do that. You can put all of them together. So, all these factors have to go in your answer. When you answer the question where it says, please draft the SLP, then you must put all those things. When you have to file a counter, on the other hand, the counter requires certain uh, what I would say mandatory paragraphs. For example, you must have a paragraph which says that all the annexures which are annexed are true copies of the original. You must have a paragraph which says that whatever you are saying in the counter affidavit or even in the SLP, or even is all which was already there before the courts below, and nothing new has been added. Because if you want to add anything new, or applications to file, put additional grounds or additional facts, all that has to be mentioned in a separate application with an affidavit in support, without that application being allowed. So this is all part of drafting. This shows that you understand what is happening. You also have to have a very good knowledge of your Supreme Court rules, because every type of application which is to be filed in the Supreme Court is supposed to be provided in the Supreme Court rules. So you must know which order and which rule of the Supreme Court rules you are relying on, even whether you're filing a contempt or you are filing an application for substitution, or any application which is permitted there, or any petition for transfer petition, for the contempt, whatever you, they are separate Supreme Court rules. You must mention those sections, because otherwise the draft is not complete. The You cannot rely on CPC or on any other act for this purpose. And I'm saying that because I've seen one application filed by a gentleman who is now also a senior advocate, very senior, and he had filed an application saying that this application for stay is on provisions analogous to Section 151 of the CPC. There is no such provision in law at all that you are analogous to 150. Firstly, CPC strictly doesn't apply to Supreme Court. You have to go by Supreme Court rules. So keep a good eye on it. Next, when you if you will look at the papers of the last 5 years, or whatever period you want to look at, you will notice that the drafting papers are very lengthy questions of maybe 6 pages, 7 pages of facts and submissions about what happened in the courts below. And then you are asked to draft a document. Please remember, you must, before you sit for the AOR exam in drafting, must have a good idea of what type of cases have been decided by the court in the last few years by the Supreme Court, and also keep a very close eye on what was decided by them. Because I can tell you, I cleared my AOR in 1986, and I remember that there was one judgment which held a certain view, and relying on the facts of that judgment in the drafting paper, the Supreme Court committee, the question which was framed by them was that similar facts given, no reference to the particular case, but said, right, file a counter on behalf of the party which ultimately lost the case. Now, in such cases, of course, you have to give the grounds, etc., as to why you think the losing party's view was correct. But if you are able to make a note that although there is a Supreme Court judgment which holds to the contrary, but in your view, that view is not correct and it should be considered by a larger bench, then there's a, I don't know now what they do, but in those days, there's a likelihood that you will get 2 marks more than the rest of them, because this shows that you are aware of how the law is done, and you are also aware of drafting in such a manner that you can raise the issue that this should be considered. Please remember that a judgment by a smaller bench can always be reconsidered by a larger bench in Supreme Court. And it goes all the way to 13 judges, number one. Number two, somebody has to argue in your draft. You have to put it that this view is not correct. It should be reconsidered. Whether they reconsider or not is a different matter. But these are small factors which will give you a little edge in your drafting. One thing I forgot to tell you, that when you are preparing your counter affidavit, you have to say that whenever you file a counter or a reply draft, You must always say that, look, whatever is said in the petition to which I'm filing a reply or a counter, everything else is denied except in specific and allowed. Now, these all sound very obvious, but I have, in my last 37, 38 years of practice, I've seen that in half of the time, the people forget, because these are so obvious that they forget to put it in. Now, this is a drafting paper, so you must have all these comments in it. Sometimes people ask the question, so how long should you take on any answer? And nobody can tell you that. If you have to draft a full SLP with all these bells and whistles, with all the documents, applications, etc., it will take longer. If you have to put in a counter, then it will be smaller. Nobody expects you to argue the case completely, but you must be aware of what are the issues possible, what are the views held by the court, and also set up. The idea is that how do you put your uh, contentions forward in a draft. There are two, three things more which I like to tell you, uh, which are my personal views. Just one second. There some people are asking questions. I'll answer in a moment. There are two or three things which you must remember. My personal view is that when you draft, whether you do it for your case or you do it for the AOR exam, please be very clear. Your English should be good because you are using English language. Punctuation should be good, and write small sentences. Don't write very long, confused, multi-clause sentences, because you are likely to lose because you are writing fast. You don't have much time. So you are likely to lose the stream of your thought. That string will be maybe broken. Number one. Number two, I always tell my juniors, please, when you draft, assume that all other lawyers are idiots, all judges will not understand, make mistakes, all typists are wrong, everybody is wrong. You have to write very concisely. Don't use too many pronouns, because people have got into habit. He has said it, they have said it. This all leads to ambiguity, misunderstanding, and that will not be counted as good drafting. What you must do is always be very clear. Petitioner said this, respondent said this, petitioner said this. Be very specific. Sometimes it makes not very good reading, but your view is clear in the draft what you put. Just one second. I think somebody has asked a question. Let me answer. What is it? Yes. Now, Mr. Mrinal Kanwar has asked that if you are not asked specifically to draft an affidavit in support of the petition, yes, in a drafting paper, you have to draft the supporting affidavit, because your draft should be such that it will be accepted by the registry and by the court. Now, you cannot have a petition without a affidavit in support thereof. Yes, if it's a counter affidavit or a reply affidavit, then the counter replies itself in the form of an affidavit. So there's no need for a separate affidavit. But you must have it. In Now, there's another question, that is there a question of law in original jurisdiction? Normally, in original jurisdiction, one would conclude that there's not a question of law. But if you are filing a writ petition in an original jurisdiction, even then, what is the law point which you want the court to decide? Because after all, mere facts are not necessary. Suit, yes, but even then, what is the legal submission you're making? My personal view is that you should put it in the draft. Now, statement of case. There's another question. Statement of case is actually, it's normally not required now, because most of the appeals and petitions are decided very easily. But statement of case is, in a manner, a short, concise form of the basic facts and then the basic arguments you have on the document. That gives them a gives them. But if you have a good drafted petition, then the case statement of case is only a what I would call a précis of the petition itself. There's no specific requirement, but you must have uh, the basic facts, not in great detail. You can mention the pages of the and the best thing is it's like a written argument where the facts are stated, and then the question, then what are the issues, and then what is on what basis you decide. Then now in a prayer in a statutory, it says if I'm sorry about the citations. Uh, if you can give the whole thing, it is good. But if you can't give the whole thing, then also at least the name of the case is would be sufficient. Then, if you can draft home many, I'm sorry, I think it's moving too many questions. Just 1 second, please. See, it says now most of the times I have noticed that there is no certificate is not required to be drafted, and certificates should not be. But in before the prayer in SLP, that certificate which is there, it should be put in the draft. Please don't leave it, because this is integral. That certificate is an integral part of the SLP, so that should be there. Yes, curative will lie even if the RP petition, if the review petition is heard in court, even then the curative will lie. Now, in my view, you must draft the synopsis and the affidavit if not specifically told in the question not to do it. I do, because that is integral. For example, in an SLP, my impression is that normally the courts tend to read the synopsis first and then decide to go into the specific documents. Yes. In a drafting paper, you must mention the title in every document, whether it's an affidavit, an application, or a main petition. It makes no difference. Drafting in original, see, you can't do it in too detail. Anything you have to draft, it depends on the material given in the question. If you have 1 page of facts, you can't generate more facts. And they are really not interested. I mean, my impression is that they are really not interested in what are the that whether you have copied all the facts into the answer into the draft or not. What they want to know is whether you understand and you are able. If you can put the legal issues clearly, if you can put the facts clearly, then even if you miss out on 1 or 2 facts, it will really not make much difference. In a statutory appeal, the prayer is always see, if when you are filing an appeal, then or even a SLP, then the prayer is always regarding the whatever your original prayer was, and to strike down the order against which you have come in appeal. What is more important is the prayer in the stay application, because you must have a specific prayer. Each prayer should be regarding a specific order or document which you want to be stayed. Don't just say stay the lower court's order or lower court, because that doesn't help you. Sometimes your writ petition, your lower court order is dismissed, and your lower court petition is dismissed. Then what is the point of getting a stay of that dismissal order? That doesn't prove anything. So ask for that, but also ask for stay of the judgment against which you have the grievance or order or administrative order. Now, Mr. Tanvi, uh, see, like I said, I did my AOR in 86, so the formats have changed. But if earlier people have told you that if they are not see, my view is look at the format as you file it, the draft. If they don't ask you specifically or something, or they don't tell you don't draft A, B, or C, then you should draft everything. The I'm told in this note which some Mr. Thanvi has sent that sometimes they say that unless you are asked to draft it, don't draft, like synopsis and affidavit. That's a personal opinion. I have no idea about it. I would say you should. Don't take a chance. But that you can, maybe Mr. Bhatt can clarify. Uh, See, this is Mr. Vasantha Kumar. Now, Mr. Vasantha Kumar, normally when you file an SLP against a review petition, you must also challenge the main order because review is also limited. But if you have not done it, then there's no point in amending the SLP. You must file a second SLP to tag it with it. That's the way to do it. Application for bail or stay when they are asked, then yes, you have to look at what exactly orders you are agreed with and then ask for stay of all of that. I'm sorry, but that this issue question of Article 131 I cannot answer. I will have to check. Yes, a single SLP can be filed against two writ petitions decided by a common order. If there are two different orders, then it can't be. You have to have a common order because ultimately it's the order which you are challenging. There may be 10 petitions in that. Uh, but what has happened is that when you have when you have a petition and then you have a review petition, then you can challenge. You can file one SLP because they are connected, interconnected. So you can challenge both the orders, the review petition and that in one SLP. Okay. Um, Now, as far as the drafting paper is concerned, uh, one good which I found useful for myself when I did give my exam was that you take the last 4 5 uh, papers, 4 5 sessions paper, that is 4 5 years papers, and go through them and you see them the way they asked because they will ask you sometimes to draft SLP or RIT. But you have to be prepared for everything. There's no rule which says you can't be asked to be draft the same thing. And as far as drafting is concerned, small, I mean, see, it has to be your personal judgment. What is required is all the necessary facts and all the necessary legal submissions should be there in the petition. Important areas of law which you are asking for drafting the paper, I told you, you have to look at last 4 5 years major important cases because they will give you facts drawn from those cases and then ask you to draft something. Like I think in last year's, I think in one of the questions I saw that they have based their first question number one on the basis of the Kaveri tribunal's case. So you have to be little aware of it as to what sort of questions they are asking. No, synopses never have cause titles, so that's not required. In a PIL writ petition, it's basically a writ petition. In PIL, you have to show right in the beginning, just before when you introduce the parties, then you have to show as to how a PIL lies. Why? You have to firstly show two things are required. One, you must be very clear to make it absolutely crystal clear in the writ petition that you have no personal interest in the matter. Because most of the PILs are thrown up on the ground that you have a personal matter, that you go by common law, don't go by PIL. That's one part. Second part, you must also show that why is it required, why is it so important that this issue should be decided by the Supreme Court in a PIL without going through the regular gamut of district court and high court and all that. Thirdly, you must also show that why if you are doing it on somebody for somebody else, you are just, then why can't those persons do it? That you have to show. So all these things are required. Otherwise, it's like any other writ petition. There's no difference in a PIL writ petition and normal writ petition. The only difference is that these three factors you have to show. You have no personal interest, the other people cannot approach, or there are too many people involved. It's a matter of public importance, um, necessary for the social fabric of the society. All those issues have to be mentioned to make sure that the public interest litigation means no self-interest. What is the public interest and why it is a public interest? You must have to mention that right in the beginning of the petition. Now, in Article 32 writ petition, again, you must be very clear in your by um, reading your constitution as to what are the uh, fundamental rights which you can, because in a 32 writ petition you can only ask for fundamental rights. You can't ask, and be very well aware, you have to explain in the writ petition why you can't go to the high court, because after all under 226 also you can go to the high court. So the Supreme Court is very fond of sending you back to high court. So in the draft you must mention as to why a 32 will lie and why not a 226. Um, as far as what sort of judgments to look at, you will have to, that is your one. I mean, look at the important which have decided important issues of law. That's very important. That is what you have to look at. Not the routine run-of-the-mill issues where they decide as to jurisdiction and all, but mainly which is little complicated, because that is where the catch comes as to how to draft it. No, I will not be correcting your papers. In synopsis, normally, yes, that's your choice whether you number or don't number. That makes no difference. That is absolutely your choice. I always prefer that you should number your paragraphs, because then it becomes easier in the counter and in the rejoinder and even in referring in the, makes it a good draft. Uh, any example about by Supreme Court you should approach? Now, the one example is that if there are multiple petitioners who are in different states and who are bound to file into different high courts, then you will have conflicting decisions by different high courts. So it is better that you file and here. Secondly, if there is already a matter pending, they can always file a direct writ here, get the issues pending here. It will be, even if we file it somewhere, we'll have to move a transfer application, so better that we file a high writ petition. Thirdly, if there are already conflicting decisions of the high courts, then you can always say that there are already conflicting decisions, so it is better that your lordship decides the issue once and twice, so it lays down the law. Otherwise, I said Article 32 is the fundamental right. You have the right to approach the Supreme Court. There is no doubt about it. Uh, in answer to Mr. Saurabh Kapoor's question, the you see the fact. You see, if you when you write a synopsis, basically what synopsis should say is what is the legal issue you are raising. That is what was supposed to be synopsis. But you can never give a absolutely legal issue only. It has to be some facts have to be given. Now, you must remember that under the Supreme Court orders or unwritten rule, your list of dates and synopsis should never be more than 13 pages when you are actually drafting a petition for filing. So what you normally have to do is you have to constrain the number of facts you can give it, because facts come in the list of dates, but bare facts have to be given. But when you are writing a AOR exam paper, then you won't have that much time. You will have to write fast and you will have to write in short. Everything will have to be in short. When you see, normally you have one mandatory question, and when you have five questions to answer, then better it is you fix half an hour for each question and leave half an hour for the spillover or for revising. That is the way to do it. Mr. Bhatt, will you now take up, sir? Mr. Bhatt, you continue now. Sir, we can't hear you. Your voice is not.
But
Can
sir,
you hear? Can you hear, but sir, I can't hear you.
sir, you're not still not audible, sir.
As far as prayer is concerned, in SLP there is a single prayer only. Permit to allow the SLP. All the orders of quashing, etc., have to go into the stay application. Besides grant of leave, there is no other prayer you can hear. All right, I'll wait till Mr. Bhatt joins. In the meantime, any other questions? In synopsis, don't have any annexures. The annexures are all listed in SLP, but in all other petitions, the annexures are mentioned in the main body of the petition, not in the list of dates. And synopsis, you can refer to it by putting in brackets and ABC, but you don't have to. And never forget to write infra or supra, so that the judge knows where to go. It is good if you can do it. A bail application, when you draft bail application, there are two ways. Are you coming in appeal against a refusal to grant bail or to give bail, or you are filing a petition and filing a criminal appeal or criminal SLP, and along with that you are filing a bail application. If you are filing a bail application, then it's like a stay application. I mean, you have to give all the relevant mandatory requirements, but it's like a stay, that is a separate application. But if you are coming against the refusal of a bail application or grant of it, then it's like a SLP or as a ordinary petition. So bail application by itself will be in the nature of an interim application. No, you must give all the grounds you want to give. Don't don't talk about any standard format grounds. See, this is a drafting paper. This is not a paper to for investigation. You are not filing a petition for filing in the court. You are drafting a petition for the paper. You all the mandatory formats must be kept, because that shows the difference that you are aware of how it should be drafted. Your draft should be such that you don't get caught by the registry and defects put into it. No specific number of grounds. See, in a answer to the drafting paper, what you have to do is, uh, you know, put out that you know how, you know the format, you know the draft, you know how it is to be done. Now, if you miss out on one or two grounds, nobody is going to come after you and deduct 5 marks that you didn't give all the grounds possible. If it was a question on law, on it like a LLB paper and all, then they may say ki, on this issue, on this legal issue, you didn't give all the grounds. But this is a drafting paper, so try have all the grounds. But if you miss out on one, I don't think they should measure one. All right. I'm sorry, but I was not aware of, this is Kakali Roy's answer to her person. I was not aware that they have included it. Then it is, of course, a prayer. Then the prayer will have to be like an interim prayer in a civil SLP. Then it will have to be there only. But keep it a separate prayer. Then it will have to be as an interim relief. See, again, the question is, uh, if you are coming in SLP against a non, like for example, refusal to grant by the High Court of bail, and you are coming in SLP, then the prayer will be separate. But if you are, for example, whatever be the prayer in the main petition, if you are drafting a bail application by itself, which can be moved later also. Suppose you file a criminal SLP or criminal appeal, you may not file a bail application, then you may file it later. In that case, the bail application, so when they ask you to draft a bail application, then all the rules that whatever, what are the basic facts, why you want the bail, why it is, all that has to be stated as a bail application. So the prayer in a bail application by itself would be different from then when it is put in the SLP or in the criminal appeal. Yes, absolutely. Mr. Naik is right. You have to focus more on the on the how it is to be done. I'm sorry, I didn't understand. How do you identify a question of law? There's a legal issue. What you? That's the very basic thing. You have to look at what the legal question are raised and make a legal question out of that. I'm sorry, I've not understood that question. Yes, you have to mention the nature of the writ. You have to mention to show as to what you want to be done because, but that's only in a writ petition. In an SLP, you don't have to mention it. Checking and marking is in not in my control. In any way, checking should be CHECK, not ECK. Ah, see, question the difference between question of law and grounds is very small. One major difference is that question of law starts with whether and the ground starts with because. But leaving that aside, see, question of law is limited. You cannot have a question of law which is based on fact. For example, if you're challenging a finding of fact, that may be a part of the ground, but it can't be a part of question of law because it is all right to say the High Court has whether the High Court has erred in giving a wrong finding, but actually that is not a question of law. So you have to limit the question of law to only legal submissions. In fact, I had a friend who is now practicing in Patna. He used to write only 3 to 4 questions of law in his SLPs, and they were absolutely perfect questions. See, the question of law is what is the legal issue, and don't go by this Bombay High Court habit of having 55 questions of law and 80 grounds. You can't do it in the AOR exam, but in any case, have if there are only 3 or 4 questions of law formed, fine, that is good enough. Even one question of law is good enough to get your for it to be a proper draft, proper petition. So don't worry about the number of it. The question of law is what is the legal issue. The grounds can be even factual as to why certain finding is wrong, certain inference is wrong, but this can't be question of law. That is the basic difference. Yes, and not you have to mention the order and rule of the Supreme Court rules. Original suit, the prayer has to be exactly what relief you want from the court. In fact, in a prayer in a suit, it gives you a lot of leeway. Plus, you have to be very careful because in an original suit, if you do not ask, it is better to have 3 more prayers than to reduce it to one. Because if you do not ask for a specific prayer, the court will never grant you, even if it is on your side. So that will be a bad draft. You must identify the reliefs you want and you must make the prayers accordingly. And you must watch out very carefully that you want a mandatory injunction, you want a temporary injunction, you want a declaration. All that has to be seen. So you have to be careful with that. Should not be. No ground and question of law should be repetitive. But yes, ground can report. See, in ground, you can put the question of law also in the form of a ground. Yes, you can put it. There's nothing wrong with that. But don't repeat the same ground, because then it doesn't leave it's not a good draft. It's not in what is called elegant draft. You can quote a judgment in the question, not in the question of law, but you can quote it in the synopsis or in the main body of the petition. But if you feel that a judgment absolutely covers the issue, then you can always cite that. Even in the question of law, said that the High Court failed to appreciate that this issue is decided by the. That would be a question of law. Yes, and you must give the declarations, because that is the uh, that shows how the thing is working, how the format works. So you must don't skip on that. It takes 2 lines or 3 lines to write it, but it don't skip on that. All these declarations under 2.2 and 2.4, etc. must be mentioned. Now, in the SLP, see, first thing you have to do is um, give the synopsis, then the list of dates, give a format as to how it is to be done. You don't have to mention every date and all. This is an AOR paper, remember, not a regular draft. Then when you write the SLP format, you must all the paras are given to you in the format, so you must mention them in the same sequence. Now remember, if you are filing an SLP or against two petitions with a common order, then you must make sure that the parties which are given in the beginning of the SLP are mentioned. In the case so and so, in the case of SLP arising out of this petition, this is the parties, and in the case of so, these are the parties. You must mention them specifically. They wanted that. Mm, no, case laws are not required means you. I don't know. How can you have a draft? Suppose a law point is in your favor but decided in a judgment, or you want to rely on it. How can you avoid mentioning the case law? I think you have to mention the case law. See, it doesn't matter how many marks you are getting in the quiz, 20 or 25. You must, you have to complete it. Please understand, I am a very slow writer. So throughout my education, I have noticed that if there are 5 questions, I always end up by doing 4.5 or 4 3/4. I never finish the paper ever. I've never finished the paper ever in my life. But that's not the point. The point is it must be complete answer. It is better to give a complete answer in 3 questions and a little bit less complete in the 2 questions than to finish all 5 but give half-baked answers. You will never get good marks. So you have to try. But keep, like I said, you keep half an hour for each question. That will be 2.5 hours, and you have half an hour extra, depending on your speed. What type of questions? Difficult questions. Tips for high school, no tips. Sorry, that we can't do. Yes, in civil appeal also, I'm not. Forget about civil appeal. Any draft you give, which is a main petition like SLP, rate, appeals, you must give questions. See, the question is, Supreme Court is not your district court. It is a Supreme Court in the sense that you must have a specific question which has to be decided. Otherwise, they say there's nothing to be decided. What's wrong with the High Court order? And they'll throw it. So your draft must contain a if a question of law is the legal issue which is raised. That is, I think, the issue. If you don't have it, it's all. No, this is the draft. Partial marks for incomplete drafting, I can't say. That the examiners will do. I'm not examining any paper. I should think even if your question of law is wrong, but you have raised it at the right step and you have a basis for that question. It may not be, it won't be wrong, but it may not be exactly the issue there. Even then, they should give you marks. Because if the format is correct, this is a drafting paper, this is not a law paper. In writ petition, they don't have to say the question or law, but yes, why not? What is the legal issue you are raising in the writ petition? For example, I'll give you an example. Suppose a person has been terminated from employment, or for say a teacher has been removed, or any officer has been removed, and you file a writ petition. Now, what is your right to that post? So you have to show what your right is. When your right to continue in that post is given, then you have to say that my order is arbitrary, discriminatory. That's the legal issue. Question of law, so you must give a reason for the judge to agree. I mean, no, it should not be. After all, if you don't write that the order is arbitrary, discriminatory, or motivated or malified, why should the court interfere? So therefore, good draft requires that. Yes, all applications are important. Transfer petitions will not have a question of law in the sense what the question is, but transfer can be done only on three grounds. One first ground is that there are matters pending in Supreme Court. There you have to state that the question of law is the same which is in the Supreme Court or which is in the High Court. Or you ask for transfer when there are matters being heard by two different or more than two different High Courts, which are raised issues. So you have to mention the issues. And it is better if you can mention that this is the question which is there in common in both of them. And if you, I mean, in a proper draft, you can reproduce the questions of law raised in the matters in the various high courts. But in a question AOR paper, you can mention there is a common law question of law, and this is a common question. But where you want to transfer, like in matrimonial matters for on territorial jurisdiction, then of course there will be no question. Yeah, don't take a chance. See if they give you two questions. See, they have 6 questions. If they give you 3 questions or 2 questions based on applications and you don't have are not able to do it, then you lose. Then your choice is reduced. So don't take a chance. Yes. Now it's about Section 2 of Enlargement Appellate Jurisdiction of Supreme Court. See, if you are coming in for saying that the punishment is not commensurate with the offense, which as granted by the High Court, and you want the Supreme Court to enlarge the issue, then what you have to do is you have to mention as to why you think it is not commensurate. And then you have to mention to some other, and criminal cases is very difficult to rely on. The punishment is a matter of, practically a matter of choice. But there are some judgments of Supreme Court which they have laid down certain guidelines as to what sort of punishment should be given. But suppose somebody is given 7 years and or 2 years and you want to raise it to 3 years, I don't know. You have to raise some issue as to why it should be done. Now, quoting foreign cases really doesn't help because after what, uh, 70 years or 71 years of our independence, I think the Supreme Court has sufficient material. Unless, for example, in stay of bank guarantee, where the question of irretrievable loss is concerned, then the only judgment which is normally available, the base judgment, is a district court in America, on which Supreme Court judgments have relied. But then again, there are Supreme Court judgments which have relied on the earlier district court judgments. You have to look at that. So, not basically, it will not. I think post abrogation of Article 370, the transfer will lie under transfer petitions. transfer petitions will be under 139. Why should it be under section 25 of the CPC? I don't think. I think. What is the difference between criminal appeal and the section 370? So, enlargement of criminal jurisdiction is basically in regard to the punishment issue, or where they want to change the offense from say serious grievous hurt to attempt to murder and all. And those are they are different. They have nothing to do with it. No. Paper book, no, not paper. You don't have to draft a paper book. You can't never draft a paper book. Where will you get the tags and all? But what they want to use is you to put it in sequence, First synopsis, then list of dates, then the main body, then the affidavit, then applications if there are any. See, curative petitions, as far as they are concerned, uh, it's a basically a Supreme Court judge made procedure, but it's only another. Says curative petitions are practically like a review petition. Only thing is when you draft a curative petition, you have to mention that judgment of the Supreme Court also, because there is no provision in the Supreme Court rules to file a curative. I don't know. I'm not seeing the latest version of the Supreme Court rules. I don't think there's any provision for curative. It is based on that judgment of the Supreme Court. You will have to mention that in view of the judgment we are filing the curative. But it's like a review petition. It's not much of a case. Index, I don't think you are required, because that is, I mean, if you have everything, I don't think index is required. I don't think index is required. No, index and listing of pro forma both are not required. No, Vakalatam is also not required. Is there any problem with the voice? Hello?
Sir, your voice is clear, sir.
Acha, because I'm getting some messages that your voice is not clear. Is it
I
okay?
think so.
Uh,
No, from our side it's okay, but I think there may be some problem from the other side.
okay. Now, what? How long do I have to go on? It's about 5:25 because Mr. Bhatt has
Sir.
not said anything.
Sir, no, there is some network problem with Mr. Bhatt, sir, and
Okay.
you may conclude whenever you want to conclude.
Okay. Now there's a
Sir,
question that
continue.
whether limitation of number of para and criminal appeal. No, there's no limitation of number of paras. No problem. Anything else? Anyway, all of you have writing position of parties SLP required. Writing position? What do you mean by? Oh, you mean no? You have to see the petitioners come first, then the respondents. So what other? I've not understood that question. The clues I've never seen. I've never heard it. Sir, thank you very much. I hope what I said is useful. In any
Thank
case,
you. Thank you very much.
have best of luck to all of you. Right. Thank you, sir. Thank you.
Thank you, sir.
I'm logging off.